Hello aspirants. Finally, the most awaited judgment has come. Yesterday on 17th October, Supreme Court of India gave its a very important verdict. The five judges bench comprising of Justice Chandrachud, Justice Kohli, Justice Kaul, Justice Bhatt, they gave a very important judgment regarding the status of the same-sex marriage. In this video, we will be discussing about this judgment and we will also see the background in very brief. So let's get started. So the history goes back to 2018 when the Supreme Court gave a very important judgment of Navteej Singh Zohar case, in which the court overturned the nature of section 377 of our Indian Penal Code 1860, which says that unnatural sex is an offense. So they turned the 2013 judgment which criminalized the section 377, and in 2018 they overturned and they said that it is no more an offense. It is not a crime. They said that discrimination to be placed upon the sexual orientation is a clear-cut fundamental violation of rights. And this was a very much needed judgment at that point of time, where it is a big achievement for the LGBTQ community. Now, there was a discussion regarding the status of the same-sex marriage. Now, we have achieved one level that having same sex is not a crime, it's not an offense. But what about the status of this community? Can they live together? Can they marry? Can they adopt? Can they have their own family? So this was the whole issue which was in question, and finally the Supreme Court has decided the matter. So we will see the key points of this judgment, what the court has decided. So they had pronounced this judgment on 17th October, and earlier on 11th May they reserved the judgment. They had a very massive hearing. They heard the petitioners. There were a lot of arguments which was going on the court, and thereafter the court reserved the judgment on 11th May, and on 17th October the judgment has come. As I mentioned, this was a 5 judges bench consisting of the Chief Justice of India D.Y. Chandrachud along with Justice Kaul, Bhatt, Kohli and P.S. Narasimha. So these were the benches. This was called as a constitutional bench. As you all know, judges comprising of at least 5 judges and more than it is called as a constitutional bench. Now, the first point, the judges refused to recognize the legal recognition to the same-sex marriage. So this was the primary question which was in the issue, whether the marriage should be allowed for the same-sex couples. So now the court has refused to give the legal recognition. However, there was a majority of 3-2 judges among the 5 judges, but the minority opinion said that marriage is a social institution and the status of the marriage should not be decided by the state. It should not be conferred by the state. I remember of a very famous jurisprudence that they said that state should not decide everything for the individual. So this was the opinion of the Justice Ravindra Bhatt when they said that it is a social institution and it cannot be conferred by the state. In this regard, the claims of the petitioners were that the heterosexual couples, whatever rights they get, same rights should be given, at least when we talk about the spouse. So they should be considered in the homosexuals also. They should be considered as a spouse in the financial matters, in the insurance issues, medical issues, and along with the succession and inheritance decision. So this was the claim of the petitioners. In return, the respondents claim that marriage is primarily a union between a male and a female, and the prime purpose is the procreation. So this was the respondent's claim, that whenever there is a male and female and their union is considered as a marriage because it is a primary focus. Now they also suggested that something which is so intrinsic in the society, let's say the belief, the custom, the culture of the society, cannot be changed by the judicial bench alone. It needs broader consultation. It needs consultation from the society. It needs consultation of the parliament. A whole Parliament have to decide whether this can be changed or not. So this was one of the very crucial aspect which was considered that it cannot be decided by the bench alone. Regarding the constitutional validity of Special Marriage Act 1954, the court said that they cannot strike down this act or they cannot read the words into the SMA because the court has certain limitation. As we see in Article 50 of the Constitution that there is a division of power in the in our Constitution which says that legislature, executive and judiciary shall work independently and they should not transgress into each other's arena. So considering that, court said that it is a legislative matter and we cannot strike down and we cannot read into the words of Special Marriage Act. They said that it should be decided by the court considering the limitation of the court. However, the court has accepted that certain rights which are otherwise available to the heterosexual couple, it should be allowed to the homosexual as well. Let's say right to cohabit and to stay free from the threat and coercion. They said that yes, we should not discriminate the homosexuals just on the basis of their gender and identity. So this is one of the prominent thing that they should be given the right to cohabit. They should be given the right to live free from any kind of discrimination. So our society shall not take this judgment as a tool to discriminate against the community. Now, they said regarding the adoption, which was another major concern, whether the queer couples are allowed to jointly adopt a child. In this regard, certain institutions has represented in the court and they raised a concern about the future of the child which will be adopted. So again, in this case, by the majority of 3:2, court decided that there will be no legal right for queer couples to adopt a child. CJI and Justice Call had a different opinion and they confirmed that this couple shall be given right to jointly adopt the child as they possess all the rights to maintain and upbring a child in a very nice and a healthy manner. But majority overruled. They said regarding the having a civil union, again the majority of 3:2 was there and they said that there cannot be a legal recognition for forming a civil union. So they denied this right and they said that this shall be in the legislature's domain to decide whether they will be allowed to form a civil union or not, whereas forming a civil union is considered as a fundamental right under Article 19 of our Indian Constitution, where we have been given this very basic right to form a association or form unions. So now even our Solicitor General Tushar Mehta has accepted that the central government will form a special committee upon the recommendation of the court and they will deliberate and they will look into the matter that what can be done for the favor of this community. And central government has also promised to form a special committee in which they will ponder upon the different kinds of right which shall be given to this community, and this committee will be formed by the government, will be headed by a cabinet secretary so that they can ensure that a proper work is being done for considering the rights of the community. So this was all from the key points of this judgment. The judgment is very crucial and we shall take this judgment very positively and hope for the best. So thank you all of you for watching this video and I would request all of you to comment your opinion in this regard. You can also tell us the loopholes and the positive points of this judgment. Thank you. Stay tuned. Stay updated.